Is it on here?
All right, can you guys see the presentation?
Yes.
All right, cool. So my name is Amaryllis Carrion. I'm a supervising attorney at Homeline. And this is a presentation for the Minnesota Hoarding. Why isn't this working? Oh. Hold on a second, I moved too fast. So what is Homeline? We're a free tenant hotline. We answer phone calls most of the time. We also do an email and attorney feature that only attorneys respond to. There's the website, but basically we've advised over 15,000 Minnesota renters on their rights and responsibilities, and tenants have to contact us directly if people have a social worker or some sort of a worker that helps them navigate issues with their landlord. They are more than welcome to contact us. We just need to have a letter stating that they want us or authorize someone to speak on their behalf. So repairs are one of the top 10 issues that we hear from during a normal calendar year. It can come from city inspectors, it can come from tenants. And basically what happens is someone will have, like, for example, a leak, and a city inspector will come to the unit and tell them about Homeline, so the tenant will call us. Tenants can also have issues. Pests is usually one of the big ones, and they'll contact the city inspector. Coupled with that, tenants should do complaints in writing. When it comes to hoarding, there are three ways that we find out about hoarding issues. It usually comes as repair problems when there is damage to a tenant's unit or to a neighboring unit. And so the key here is that the landlords have to do the repairs. They can pass on the cost for the repair to the person who has caused the damage if they can show that they did it, that it was their responsibility, it was a tenant, or the person who caused the damage is the one who caused it. So, for example, there's a leak behind the wall. That's not likely an issue that the tenant caused. It's just a leaky pipe. But for example, where there's pests, that can be tricky. If it's mice or roaches, it could be a combination of just bad issues in the building, but it could also be just amount of clutter in a unit. If there are bed bugs, if people are bringing in stuff from the street, that could be attributed to the tenant. It's a little bit hard to attribute it to a tenant, though, because there needs to be a direct link to it. But a landlord can bring enough evidence that suggests that it was a tenant who caused it. The key to deal with repairs after someone sends a repair request, the landlord has 14 days to address the issue. If they don't, then a tenant can bring a rent escrow action. What that means is they file a case in court against the landlord. The rent is paid directly to the court and is held in an escrow account. Filing fee is around $70, but tenants who receive a Section 8, Section 42, or an MFIP, SSI, food stamps, qualify for the informa papieris, which is the fee waiver, so they don't have to pay that fee. Like I said, you can't start this action until 14 days have come and gone from the tenant notifying the landlord about the issue, or if there's an inspector report, which is very typical for mold issues or like massive pest infestations in a unit. Then the deadline for that report for the landlord to have completed the repairs required in the inspector report, that must have lapsed also. There's also a tenant remedies action. What that is actions that are for emergency issues, like there's no running water, no hot water, access to sanitary facilities. Heat in the winter is a huge one. There's no electricity. And then there's like an other category. So for example, not having a working stove is ETRA worthy, but not having a working refrigerator isn't. So, but if you have diabetes or have medications that need to be refrigerated, then you could probably go ahead and have your tenant file for an ETRA. The filing cost is really steep, it's $300, unless there's a fee waiver that can be applied. And if a tenant is sort of questioning whether it's an ETRA or a regular rent escrow and they qualify for the fee waiver, my advice is always file the ETRA, because if it's not ETRA worthy, the court will drop it to a rent escrow. This is landlord issues with invasion of privacy. I've noticed are very, I'm not going to say rampant, but are common for people who have clutter in their apartments. Landlords can only enter units if they have a reasonable business purpose and have given or attempted to give notice to enter. There's an emergency exception, like if there are leaks, there's a fire, obviously. I don't know, deathly smells coming from a unit, screaming in a unit. Those are emergency situations. Minnesota doesn't have a specific time period where a landlord needs to give notice. People tend to think it's 24 hours. The standard really is reasonable notice. It could be more than 24 hours, it could be less. And if a landlord enters a unit on an emergency basis, or because you submitted a repair request, they do have to leave a note saying that they were in. It has to be visible. I know a lot of tenants tend to be hesitant about having maintenance enter their unit when they're not present. I 100% understand that. It's not something that they 100% need to worry about, because the landlord would have had a reason to enter, especially if you've put in a repair request. It's a little bit hard. It delays the process, I guess, if you have to be present and you're working, because maintenance still usually works at 9 to 5. Retaliation. This is something that also applies a lot to people who have some clutter in their units. Obviously, the ADA applies, but in general, landlords can't take adverse action against a tenant when they enforce their rights. So say you submit a repair request and you have, I've seen this before, like there's sort of clutter, there's like big pieces of furniture that are making access to certain areas more difficult, and the landlord's just like, well, no, I'm just going to evict you for a lease violation. No, you as a landlord have to work with that person to make sure that you get access to what you need to get access to, because you still have a responsibility to maintain that unit. Things that landlords can do in terms of taking adverse action: increasing rent, telling a tenant that they're not renewing their lease or giving them a notice to vacate after they've asked for a repair request, threatening with eviction, or decreasing services, which is a big one. Say a landlord walks in and they're like, oh my God, there's so much stuff in this unit. This is why we have mice. I'm not going to treat the mice. You have to get rid of all this stuff. No, the landlord still has to treat the mice. Obviously, then you would put the tenant in contact with services to help address the clutter problem, but you don't just wash your hands and say, I'm not going to deal with this. The protection against retaliation is 90 days by statute. And during that time period, the landlord has to show that whatever action they took was not retaliatory in nature. Neighbor complaints are another one of the big ways we at Homeline find out about issues with clutter or hoarding. Landlords have to keep premises and common areas fit for their intended purpose. In this case, they need to be habitable if you want people living there. So say I have a neighbor and I've noticed an increase in pests. I send a letter to my landlord saying the pests are coming from so-and-so's unit. the landlord goes and does a check, they find that there's an issue there, the landlord has to deal with the situation. The dealing with the situation is not, I am going to evict you. The dealing of the situation, and this is because the ADA covers people on this matter. There's a reasonableness component to it. So landlords really need to work hard at accommodating the process of improving living conditions for people. You still need to take into consideration your neighbor who's dealing with the past, but you have to balance that with the need of the person who is in need of services. A key component to this, though, is that because the landlord does have to take into consideration the neighbor who is experiencing a pest issue, or maybe there's water damage, landlords can ultimately file for eviction if the tenant who needs services is unwilling to enter into a process of improving their living conditions. And this is the tough balancing test, because the thing is, landlords really can limit who live in their rental units, and they have to make it safe for everyone to live in properties. Now, specifically with hoarding, what you will see people talking about is the covenants of habitability, which is the unit being available to be used for its intended purpose. And the question is, what is reasonable, right? Because we can request a reasonable accommodation to have the tenant clean their unit or seek services, but what is reasonable? And as a lawyer, I can tell you, it's our favorite phrase. It depends. If you have, well, my suggestion is always enter into some sort of settlement agreement, where the tenant in question will clean the unit during a specific time period, seek services, and you have to be careful about agreeing to unscheduled inspections, because this could become a privacy issue. Additionally, as you all know, improvement is not linear. We have ebbs and flows. You know, people have medical conditions. They might have processing disorders. They might have anxiety. They might have depression. It's very difficult to expect someone to just say, clean up, get rid of all this stuff by snapping your fingers. That's just not how this works. So you can agree to inspections to see progress. Just don't ever agree to unscheduled inspections. The ADA will always apply in these cases, and really focusing on skills is critical, so that people who tend to have more cluttered units can sort of have a system of getting things out of the unit, or being better able to organize. Generally speaking, we refer cases like this to legal aid or in Hennepin County Adult Representation Services. The reason being is that landlords will tend to push for eviction, and we know from statistics that tenants who are represented by counsel tend to do better when faced with situations like evictions or settlement agreements. Improvement plans is usually the key thing, like I've said before. We don't track hoarding issues independently. Like I said before, it's usually repair issues, neighbor complaints, or at least violations, which is how landlords tend to bring them up in eviction court. I can tell you that during the pandemic, I noticed an increase in calls from tenants who were being questioned by their landlords about possible hoarding. And part of this was because services were not available, in-home services were not available. So this is why working on developing skills is very important, and communicating the plans with the landlord. I'm gonna say, like, in the past month and a half, I've had 5 calls that I can tell you straight out were people who were desperately in need of services and were being pressured by their landlords. A lot of times these is just things that can be fixed, right? Like I had a caller who had really big furniture and it was blocking the vents for the air conditioning / heat. And so the furniture needed to be moved forward and away from walls. Now that's also important because you want to create airflow, so you don't have mold developing on the walls. I remember I had a client once tell me, and I didn't know much about sort of creating like walkable areas or pathways so that emergency services can access the units. And I remember that this caller was well versed on this. Very well versed on the skills and the things that they needed to do to be able to maintain safe housing. And so that helped me a lot because then I was able to communicate this to the landlord. Like, look, this is what we're looking for. This is what this person needs to have in place until the pandemic ends or until they're able to get their organizer into the unit again. And so good communication with the landlords is very important. Sometimes, well, not sometimes, I'm going to say 100% of the time. It's very hard for a tenant to do it on their own. They need an advocate, and it can be an attorney, but it can just be someone from your organization who has that conversation with the landlord. I always say put things in writing. It protects you from the landlord saying at a later time, well, I didn't say that. Or it also helps landlords, right? To say like, look, Joe or Jane or John Doe, like this is what we agreed to and you're not following through. And so how do we get back on the plan and make this a safe living situation for everyone? Notices to vacate. So this happens, what I've noticed is a lot of tenants who are in low income housing will start with a 1-year lease and then eventually will turn month to month. If you have a client with who has clutter issues, landlords will be like, well, I'm just going to give you a notice to vacate. They can do that. Tenant can push back, right? Like you need to accommodate this, and this sounds retaliatory in nature, and then you would bring in a legal aid attorney at that point. But landlords don't have to renew leases that have expired. They just have to give you the notice period. So if it's a 1-year lease, they tend to be 60 days, month-to-month leases, they're 30 days, and this is generally speaking. Brooklyn Center does have a good cost provision, and so do federal programs like Section 42 and other types of public housing. Something I've noticed is tenants will say, well, the landlord gave me a notice to vacate because they don't like me. That in and of itself isn't retaliatory in nature. Again, because landlords can choose not to lease the property again. But if you have open communication with the landlord, you can see what the pattern and practice is. And that could help you start a conversation to come to a place where you can communicate effectively. And for landlords, what I always tell them is, look, this isn't about getting rid of the quote unquote problem. Tenants are not problems. Medical conditions are not problems. You want the unit to be rented. You want people to be housed, or people want to be housed. What can be done to get to a place where everyone is content? Notices, though, have to be properly timed. It's usually at the same time the tenant has to give their notice. So if it's a 60-day notice, tenants has 60 days to tell the landlord whether they want to renew their lease or not. The landlord has to give them the same amount of time. And the reason I put this in the presentation is because there are some leases, it's not as common anymore, where the landlord required a tenant to give 60 days, but the landlord would only have to give 30 days. And so that power imbalance is no longer allowed. Now, security deposits, there are two things that have to happen for the quote unquote 21-day rule to kick in is the tenant has to provide their mailing address and the tenancy has to end. Basically, landlords have 21 days to refund the security deposit, and they can only hold deposits if there's a debt owed under the tenancy and for damages that are beyond normal wear and tear. This tends to happen, say you have someone who's lived in a unit for, I don't know, 15 years. And then the landlord's like, well, the carpets need to be replaced, the place needs to be painted. I don't know. There's some water damage in the bathroom. That might not be something that they can bill a tenant for unless it's beyond normal wear and tear. Having to paint a unit after 15 years, not unusual. Having to address carpet issues after 15 years, not unusual. However, if you have clutter problems, then the wear and tear is more likely to happen, right? That wear and tear that's not ordinary, so that it's beyond that. And then tenants should always document the conditions of the unit, definitely on the first and last day of the tenancy, but you can do that on a schedule. And this is because if there are repairs and say, I don't know, there was a leak on a wall and they came and removed some tile in the bathroom and they just plastered it and they didn't put tile on top of that again. You can be billed for that if there's additional damage that happens. Evictions are court cases. What landlords can win is just possession of the property. The filing cost is around $300. Normal eviction time is 20 to 30 days. Right now, we're not on normal times, especially in the metro area. Ramsey, Hennepin are pretty far behind in their eviction calendars, and they're trying to figure out how to deal with this. I know Hennepin County has what I like to refer to as the cattle call, which I think it's on Tuesdays and Thursdays. And they're sort of inviting tenants and landlords to show up and try to reach agreements. Over 90% of evictions are filed for non-payment of rent, but for issues that concern, you guys said, the Hoarding Coalition or task force, I'm sorry, it would be more of a lease violation issue or infractions where a tenant has had a lot of neighbors complaining about them. The landlord will send infractions to the tenant to comply with X, Y, or Z, like you have to get rid of some of your stuff, you have to clean your unit more frequently. And then eventually, when you have enough of those infractions, landlords can definitely then file for eviction. Key eviction defenses, where if it's for non-payment of rent, you can pay what's owed. If it's compliance with cleanliness of a unit or being able to grant access to a unit for repairs, usually that would be a settlement agreement where you agree to let the landlord in and do the repairs. But the landlords have to serve people properly, so that's another defense. Something in the complaint is wrong. I don't know, they have the wrong name parties. So you always, as a tenant, need to read the court papers, and you can look them up in MCRO and MNHTF. Those are the public side of the court filing system. And always, obviously, contact us at Homeline. You can contact Legal Aid, Volunteer Lawyers Network, Adult Representation Services in Hennepin County. And those are, it's free legal aid that tenants can receive. Lockouts. This is another way that landlords tend to try and force people to move out when they're having tenants that they consider difficult and they just quote unquote want to get rid of the problem. They'll change the locks, shut utilities off, etc. That's very illegal. It's a criminal misdemeanor. There are big civil penalties. The tenant can sue for $500 or 3 times the cost plus attorney fees. Oftentimes landlords will threaten a lockout, like I'll change your locks if you don't get rid of your stuff. I'll change your locks or kick you out, put all your stuff outside. they don't follow through. It's just a silly thing for them to do. I think my time practicing law in Minnesota, housing law, I've seen it probably 3 times. And they happened during the pandemic. That's just my experience. I know that other people have seen it more often, but it's just something not particularly smart for landlords to do. But I know that it can affect tenants, especially people who have disabilities, because accessing housing is so difficult. Getting a place to live that's affordable is so difficult. It really will make it rattle people to the core. And if you have if you tend to accumulate more stuff, it can exacerbate the desire to have more, because your fear is that you're going to lose it. So accessing services, and for groups like y'all to be able to contact us with a tenant so we can de-escalate the situation is extremely important. To handle lockouts, basically, it's just it is an emergency petition. We can walk people through it at Homeline. Legal aid will take those, I know, as long as you meet the income requirement. And the hearings happen almost immediately. Breaking leases is another thing that I tend to hear a lot from clients. And it's really hard to do because it's a binding contract. The few exceptions that exist where you don't have to pay a fee is if you are a victim of domestic abuse, the military has called you up and given you orders, if there's a death of a tenant, or what we call constructive eviction, which is that the conditions in the unit are so unlivable that you have to move out. Like, there's just no option. And so you can break the lease, and then the landlord will try and sue you, and you'll go through the court process. Emotional support animals. I'm a huge supporter of them. I think what's key here is tenants can't just declare this is my emotional support animal. They really do need to go through the process of filling out the paperwork so that the landlord can authorize it. And obviously the tenant will be responsible for any damage the animal causes in the unit. But landlords can't charge pet rent or an extra deposit for that animal if it's an emotional support animal. It's covered by the ADA. And I do have some documents that I will email you all to have on your records to guide tenants through the process of what is an emotional support animal and what needs to be included in that medical note. Some landlords will have a specific form that they want doctors to fill out. That's perfectly fine. It makes the process just a little bit more tedious because you have to talk to your doctor, have the medical secretary fill out the documents. But once that's in place, unless the animal is being a nuisance, biting people, for example, it should all be okay. So this is the Homeline information with our website. We do have a Spanish, Hmong, and Somali line. I'm a Spanish speaker, so I also help with Spanish calls. And we give these presentations all in Hmong, Somali, and Spanish also. So thank you. Let me.
Do you have any questions in the chat? I didn't invite people to put questions in the chat, but you could.
Oh yeah.
Or you can unmute yourself and ask a question. Be welcome as well.
Yeah, you guys feel free to ask me specific questions. I can tell you that lately, this past month, for some odd reason, like I just took a lot of calls from, whoa, I can't see myself with this light behind me. Sorry about that. Now I can't see myself, period. Yes, we have the light.
You just have to be a glowing angel.
Yeah, I know, it scared me. I think the pandemic affected a lot of people. And it's made landlords more hesitant to keep tenants that normally they would have been okay with having. But I think things seem to be changing, and like I know this is your bread and butter, but getting tenants to develop skill sets is really important because it's those little things that are going to keep them housed. And open communication with landlords. Those are the key takeaways from this. We can definitely walk them through the process of if they need repairs in their unit and they're terrified of having a landlord come into the unit. It's a valid fear, very valid fear. But we can work with you guys into how to get the unit to be in a place where a landlord can come in and do the repairs that need to be done. And in cases like that, then the reasonable accommodation becomes very reasonable. Because if the fire department isn't complaining, and if neighbors aren't complaining, and the landlord has access to the areas they need to have access to, how much stuff is in a unit? Like my idea of clutter might not be someone else's idea of clutter. Like I'm not Kim Kardashian who needs a minimalist house that looks like a museum. Some people have heirlooms and they want to keep them, and it's not my job to tell them they can't have them. Is how can they have them safely in the unit and keep the landlord off their back?
Do you use the uniform inspection checklist?
We do have it. It's really up to the landlords to have them, but tenants can use it themselves.
Do you find that you're introducing that to landlords, or is it something they already know about? And
some landlords do, some landlords don't. It all depends of whether they're big corporate landlords or mom and pop.
Okay.
Groups. I know like mom and pop shops tend to hire property management companies, so they will use that inspection checklist. For reasonable accommodations, if you kind of stick to what the requirements are in the city so that emergency services can enter the unit and landlords can do repairs, that's kind of as far as they can go.
Carlos, I liked how you touched on the skill set piece because it reminded me of a few of the people I work in property management, and a few of the people that I worked with recently my role, I'm kind of like, I work as kind of a bridge between our managers and the resident. And I had a resident who wasn't able to do everything on the checklist, and they knew they weren't going to be able to do everything on the checklist. And so they said to me, they're going to evict me if I can't do everything on the checklist, and I already know I can't, so I'm not going to do any of it. And so, then I was able to have this conversation with this resident about how, let's see what are the items that you can do. What is it that we can address? Let's start there, because if you can at least show that you are doing these items you can, then that might not be the outcome. And so that and the other thing it got me thinking about is that a lot of the people I work with are also scared to open their mail and read what it is and when people are coming. And that is another skill set I think that is to encourage our residents. So.
I mean, I've noticed the people that I've talked to, the 5 people that I've talked to in the past month and a half, were very good at dealing with email. Why email over mail is better, I don't know. It also doesn't matter. If that's what works for the tenant, then that's the process we should follow. There's this one particular person that I remember kept telling me about how much stuff could be in the hallway, like how many inches needed to be clear. And I was like, I didn't even know that was a thing. But it made sense, right? Because the way I look at it is, can we get sort of a wheelchair, or if the EMTs have to come with a gurney, can it walk through the hallway? But I remember for this particular person, that type of knowledge was great, because during the pandemic, when everything was closed and services weren't able to come in, that's what kept them afloat. that's what allowed the landlord to be like, you know what, it's okay. Once everything opens up, I know we're going to be able to start tackling whatever buildup we might have. And so, I mean, it's just open communication is very important. I think it's really hard to convince people, to get them over their fear to have someone come into their unit, because there's a lot of shame attached to it. But the thing is, it's just my take on this is most landlords just they want their units rented. They want units. They want someone who pays their rent, and that's it. And so they're going to work with you. And there are services out there. So if you're getting services and you have open communication with the landlord and there's some improvement, then things are going to be able to continue working out. At Homeline, obviously we encourage people to seek services. I mean, I have a running list of who to refer people to, because the last thing I want to see is someone face an eviction. It basically, especially if you're low income, it makes it nearly impossible for you to be able to rent. And also, if you have all these mementos, there's a reason why you want to have these things, that you're surrounded by these things. The worst that can happen to you for your mental health is to lose them all. So, which is what tends to happen with an eviction, right? Because you can only take with you so much. And then you will see it saved for 28 days and then thrown into a dumpster. And that is a way to get people to just completely lose it. Just and I know for a fact that that's not what landlords want to see either. For practical reasons, because you don't want that in front of your building, but also people are human. Like, you don't want to see people suffering. So yes, tenants, talk to your landlords. Landlords, communicate with your tenants and put them in touch with services. I am so sorry that I don't.
Don't worry about it.
I know, I'm like, should
You're
I?
incognito.
Please.
All right, any other questions?
So I have a quick question. I work for a city and we recently issued correction orders for a large amount of household garbage that was sitting around, and the landlords actually said, we can't take that, we'd have to hold it for 28 days. But it was actually household rotting garbage. So the city ended up, we were gonna step in and just abate it and remove it. But I'm curious as to, if you can give an opinion as to where household garbage falls within that 28-day needing to keep items.
So it's tricky, right? I can see why a landlord would say, no, we're going to hold it for 28 days. Look, if it's a hazmat issue, it has to be thrown out. Rotting food, worms, it has to be thrown out. The 28-day period is for property that is left behind by a tenant. But if the property has been contaminated, the best thing to do is document what was left behind, so that you as a landlord have protection. That, look, this is why this had to be disposed, and then try and save what hasn't been contaminated. If you have an order from the city saying that the stuff has to be removed, it has to be removed. That, because you will have a defense if the tenant decides to sue you in conciliation court, which is where you would sue for damage to lost property. And it is always going to be a balancing test. It's never going to be cut and dry.
It depends.
It depends, but it depends. But really, if it's stuff that's rotting, it's just document and follow the city's order on that one.
Thank you.
Welcome.
Okay, call for questions. Thank you, Amaryllis. It was amazing.
You're
I
welcome.
really appreciate your expertise. And I hope we can send some people who need your services your way. You told me how many emails you have
Oh, God,
in a
yes.
day earlier when we spoke, and I'm shocked at the ability to process that. I don't know where your funding comes from, but you should get more.
Yes, we should. Please, like, we definitely, it's interesting. We're grant funded by the cities and the state, and some private organizations, but, definitely you guys can contact us and maybe we can partner up in some way, shape or form, because it would be interesting to have Homeline serve as sort of a starting point for y'all to refer clients to and see what else can we do besides, what we
Well,
are doing.
definitely double check that you're on our resource list. So I'm pretty sure you are already, but I'll make sure all of that is up to date. And I'll make sure that they know that there's multiple languages available too.
Jennifer, could I ask a question?
Sure.
Annalise, have you had much experience with, so if somebody has a diagnosis of hoarding disorder, what is like the route that they could receive like an accommodation from their tenant to be able to have like a better chance to help remediate the situation to avoid eviction? Like, where does like ADA and the disability laws like fall in with somebody in that eviction scenario if they have a diagnosis?
So if the landlord has already filed for eviction, there's going to be you can negotiate a settlement agreement. Really up until the date, even if there's a trial going on, until the judge or the referee makes a decision, you can settle. And if the landlord is threatening eviction, what I always suggest is to put a performance improvement plan in place. I like plans that are 90 to like 3 months to 6 months. I know attorneys from the tenant bar would not always be happy with me when I say 6 months, and it depends on the conditions of the unit. The ADA applies 100%. It's just a matter of what's reasonable to accommodate the needs, right? So if you have a performance improvement plan, what you want to show or want to have in writing on it is that the person is receiving services, what the services are, usually a plan of the skills that the person is going to be developing, and then having a clear list of the areas that need to be tackled immediately. So short, near, and long term. And inspections, right? Inspections are always important. I don't like unplanned inspections because of the privacy piece. So I always advise not to agree to those unless it's extremely necessary. I think 28 to 48 hour notice on an inspection is good. And then if the tenant doesn't comply or is unable to comply, or if they are doing really well and then sort of take a few steps back, you can extend the agreement, right? For the amount of time that there was a setback. I think, like I said before, landlords are usually willing to agree to this. The things that always need to be addressed is if there's rotting food, if there's infestations, if there's mold problems, those things need to be addressed immediately. So you have to be able to give access to the landlord to do repairs. If vents are being covered, they need to be uncovered. And I know people sometimes have really heavy furniture. It still needs to be moved, because that's how mold comes about. And then pests, there's usually treatment plans. Landlords will have an exterminator go every 3 weeks. I think it's what I've normally seen. as a tenant, they would have to agree to allow access so that the extermination can happen. Because this is about trust, landlords need to be very aware that trust goes both ways. In order to see a tenant improve, you can't just show up for an inspection with 7 people taking pictures, because that's going to breach the trust, because it looks more like you're trying to get evidence to evict instead of to keep the person housed and have the conditions improve. And it could be argued that that would violate the ADA. I say it could be argued because it's just a standard of proof for housing court is not the same as in criminal cases. So the tenant can still make the argument that you're harassing them. And you have you've agreed to a performance improvement plan and you're not sticking with it. I hope that answered your question.
Thank you.
Awesome.
Oh,
All
and
right.
the thing is, if
Go
you need
ahead.
help with how to draft an agreement like that, definitely email us at Homeline. I can definitely send an email with a suggested language. I do that all the time. And it's something, obviously, the landlord's attorney will also have input on it. If it's someone who qualifies for state services, then legal aid attorneys or adult representation service attorneys will gladly take over and negotiate that directly, so the tenant doesn't have to be sort of also tackling that language themselves.
Can you say the website address?
Oh yeah,
Just for
it's
the record.
homeline.mn.org. And on the right-hand corner, there's an email an attorney feature. You can also just email me directly. So it's AMARILISC@homelinemn.org.
Thank you, Amaryllis. That's awesome. It's great talk and important information. Thank you so much for sharing it.
You're welcome.
And send us the bill.
I will. You'll be getting it from Deb, our office administrator.
Okay, thank you.
All right, I'm gonna log off, but feel free to email me if you have any other questions.
All
And
right,
I'll
thank
email
so
you the presentation just so that you guys have it.
Awesome. Thank you so much. Thank you.
Bye.
Bye.